Thank you. I'd like to thank the organisers of this conference for inviting me here, the Centre for Disability Law and Policy, Amnesty International, the School of Law. I'm always delighted to come to Ireland, the land of my forebears, and the hospitality here is always absolutely brilliant. But I want to start by saying this is an incredibly important day for Australia. I know there are some Australians in the audience, and I think you from Ireland will appreciate this. Today, the Australian Mayor, Black Caviar, is running at Ascot. She is going for her 22nd consecutive win. And we really, really want, as a matter of Australian pride, for her to beat all those English horses. Okay, so I might have to sneak out just before we finish at about 3:45 just to check how she's going, because it's very, very important. What I'm going to do with this presentation is just to provide you with a general overview of recent trends in mental health laws. Before I do that, I just want to explain a little bit about the work we're doing and the centre that I'm directing at Monash University. The Centre for the Advancement of Law and Mental Health was set up in June last year, and here are some of the people involved. It took us about 18 months to set this up, not only because we had to go through a lot of paperwork and so on, but also it took us 18 months to get the acronym right. So initially it was going to be the Centre for Law and Mental Health, and then we realised that was CLAM. Then it was going to be the Centre for Law and Mental Health Policy, and that was CLAMP. So now it's the Centre for the Advancement of Law and Mental Health, which is CALM. Okay, so wonderful, wonderful acronym. Here are some of the people who work with me at the centre. At the moment we have 6 PhD students. 2 students have already obtained their doctorates. And we're hoping to expand the centre as we go along. So it's been absolutely wonderful for me to be here and just to see what's happening at the centre here and how it's set up and how you've actually got your own rooms together. It's just fantastic. So we're learning as we go along. Most of us have legal backgrounds, not all, but we also have backgrounds in other disciplines such as nursing, medicine, psychology, political science, criminology, and so on. And we're very keen to do cross-disciplinary work as part of our research. Some of the work we're doing looks at different aspects of mental health laws, but it's going a little bit further than that now. So we look at civil justice, criminal justice, social inclusion matters, but we've actually just put in for funding for a mega project looking at the intersections between these topics. Because what we're finding is that even though we started off just thinking about mental health issues, there's such a crossover with disability, with alcohol, substance use and so on. And we're really keen to explore some of the themes that occur across disciplines. I think in the past, and I think Mary's going to talk about this, we've always had segregated systems, you know, the mental health system, intellectual disability system and so on. And there's not enough crossover, there's not enough communication. So we're very keen to remedy that as we continue our research. Right, just a bit about the presentation that I'm using. It's a little different to the handouts you have. I'm actually using some artwork here from the Cunningham Dax collection in Melbourne. It's a very, very important collection of artwork by those who have experienced some form of mental health problem. And I'm using this on the basis that a picture paints 1,000 words. And I think you may forget what I talk about, but hopefully some of these images will stay with you. They really provide a different perspective from those who have had some experience with involuntary commitment and so on. These images are subject to copyright, which is why you don't have these images before you. So it's a special treat for you who have given up your Saturday to be here to be able to look at these amazing artworks. As part of the Centre's research program, we've actually been carrying out a 5-year project. We're coming to the end of that project now, but it's been the first time in Australia that anything like this has been done, that we're comparing mental health laws across primarily common law countries. And as part of that, we've been carrying out interviews, and we've completed about 75 interviews with people across Australia, New Zealand, Canada, and also England, Scotland, and here in Ireland, just a few in Ireland. And it's been fascinating to see some of the similarities between the issues that arise in relation to our mental health systems, even though in practical terms they can be quite different. And I'll be picking up on some of the themes that have emerged. All right, so let's think about some of those trends. Obviously, a lot of the presentations today will mention the important context of the Convention on the Rights of Persons with Disabilities and what this is doing in setting the scene for reform of mental health laws. In the past, I think, in analysing mental health laws, we've concentrated on the right to liberty. And certainly autonomy, self-determination and so on has been an important factor in measuring the scope of mental health laws. How far do you go in enabling involuntary detention and treatment? Interestingly, the UN Committee on the Rights of Persons with Disabilities, in looking at the communication from Tunisia, talked about the need to repeal legislative provisions which allow for the deprivation of liberty on the basis of disability. And this is obviously one theme that I think will be explored today, and I think Professor Dander might take this point up as well, that when we think about mental health laws, we really have to justify why they exist in the first place. We don't have cancer acts, we don't have epilepsy acts, diabetes acts. Why is it that we have standalone mental health laws? And I think that's the starting point. Why do we have them? Now, they might be justified on the basis, well, it provides access to treatment. It might be justified on the basis that it prevents self-harm, harm to others and so on. But I think this is the starting point, that we need to actually challenge why we actually have these laws in the first place. In relation to recognition of legal capacity, we're going to hear a lot about this today, and Professor Dander, of course, will be speaking primarily about this. So I probably won't spend as much time on this. You'll be hearing a lot. But in relation to Article 12, we now have this presumption of legal capacity. And I've just finished writing a piece where I actually talk about it in terms of legal standing. And as we heard at one stage, women didn't have legal standing, children don't have legal standing. The whole notion of civil death for prisoners. Once an offender goes into prison, they were seen as the civilly dead, absolutely no rights and so on. So different groups in society have been given the status of not having any legal standing. Obviously, Article 12 challenges that. But I think it goes further because it's looking at legal agency as well, the ability to exercise one's rights. And Professor Quinn here has spoken about this in terms of it being a shield and a sword, so that it means as a sword, a person has a right to make decisions for him or herself and to have those decisions respected. In terms of it being used as a shield, it refers to the power of the individual to stop others from making decisions on his or her behalf. So I think there are two aspects to legal capacity that need to be explored, but it seems the focus at the moment is on this notion of legal agency. What does it mean? In terms of Article 12, it talks about any limitation having to be proportional and tailored to individual circumstances. It also seems to be pushing this move towards supported rather than substituted decision making, and I'll come back to that in a moment. The other aspect of the CRPD, which I think might be forgotten sometimes when we look at mental health law reform, is Article 25, and what this means in terms of the right to the highest attainable standard of health, including mental health. This is incredibly important. In the interviews that we've conducted over the past 4 years, the theme that keeps emerging is not so much about coercion and force and so on, but it's about access. It's about access to good quality mental health services. And many people have said, if you fix the voluntary system, then we won't have to worry as much about laws for involuntary detention and treatment. Some consumers have said to us, we would like to be voluntary patients, but sometimes we're a bit scared that we'll be made involuntary, so we kind of ignore what's out there. Others have said we desperately wanted to get help. Carers in particular have said they wanted to get help for family members, but they couldn't. They weren't sick enough. There weren't beds available. It's very much a crisis-driven system. And I think that seems to be common to so many countries, that the focus is so much on involuntary detention that it becomes crisis-driven. In relation to Article 25, obviously it's a positive right, so it places obligations on states to provide mental health services needed by those with disabilities. And I think it's important to explore what this means in terms of government duties. And it's important for this to be used a lot more. I'll come back to this in a moment as to how the law can perhaps help in relation to access to the highest attainable standard of mental health. Okay, so I wanted to just raise 3 different trends in this presentation. There are lots of others, but obviously time is short. Supported decision making, I think other speakers will talk about this today, but obviously a lot of governments, policymakers are grappling with the idea of what does this mean? How can we actually move from substituted to supported decision making? There is perhaps a view that this means the complete abolition of substituted decision making. It was interesting that the United Nations Committee on the Rights of Persons with Disabilities in the Tunisia communication talked about it reviewing the laws allowing for guardianship or trusteeship and take action to develop laws and policies to replace regimes of substituted decision making by supported decision making. But interestingly, it didn't actually go so far as to call for the immediate abolition of these laws. And I think in reality, some people might argue that it shouldn't be the case, but in reality, this may be a matter of progressive realisation. We're all grappling with what supported decision making means. And as I said, other people will take this up in the conference today. In relation to what's happening in Australia, the Victorian Law Reform Commission, Victoria is the state that I come from, has recently completed a review of the guardianship laws there. They have put together an amazing document. It's actually 600 pages. There are 400 recommendations. So I've been spending a lot of time reading this particular report. But what they've recommended in terms of changing guardianship laws is that it be replaced by a sort of, I'm not too sure whether to call it a hierarchical approach, but different approaches to the matter, so that what they call the substituted judgment approach is very much one of last resort. And they have suggested that there be supporters that can be appointed by the person concerned or by the relevant tribunal. And the role of supporters is to actually seek out information and then to discuss the information with the person concerned and to communicate decisions on behalf of that person. They've also suggested co-decision making, but after attending Michael Bark's roundtable discussion yesterday, I heard that in Canada apparently there's a move against co-decision making because it might easily slip into substituted decision making. So I found that interesting. The Law Reform Commission in Victoria has recommended that there be an online register so that doctors, banks and so on will know who the support person is in this regard. And interestingly, they have said that there should not be a best interests approach. In our mental health laws in Australia, we don't have a best interests test at all. That just doesn't exist. It does exist, however, in guardianship laws, and I think it's significant that the Victorian Law Reform Commission was very critical of it. They said it was very vague, it could be used in a way that was very paternalistic. We know what's good for you, we know what's in your interest, therefore you do this. So that's why they've come up with this substituted judgment approach, which is based on the idea of promoting the personal and social well-being of the supported person. So it's very much following what the CRPD sets out in terms of looking at the will and preferences of the person involved. In terms of financial decision making, they've recommended what they call the prudent person principle. I'm not quite sure what that means yet, but obviously, again, they're trying to set out a case for the support person to look at promoting the personal and social well-being of the person being supported. So that's just an example of what we're doing in Australia in terms of trying to get a framework of the CRPD in practice. All right, access to services. I want to come back to this because I think it's important. Now, what role does the law have in relation to providing access to services? Now, Article 25 talks about this right to the enjoyment of the highest attainable standard of physical and mental health without discrimination on the basis of disability. I think there may now be emerging a trend from a focus just purely on laws relating to involuntary detention and treatment to developing laws that encourage a right to mental health for all individuals with mental health problems, and obviously supported by a right to access appropriate mental health services. Mary Donnelly has written a very important article about the move away just from a focus on autonomy to a focus on social and economic rights as well. And I think we can see a shift emerging here. Now, a number of jurisdictions have legislative provisions dealing with voluntary admissions, as I understand the Mental Health Act here in Ireland has. Some of them just talk about a general principle whereby a patient's consent is preferable to involuntary admission and so on. But what I find interesting is that in some jurisdictions it goes a little bit further. Under the Northern Territory Mental Health Act, a person can actually appeal a decision to the Mental Health Review Tribunal if they have not been admitted, if they've been refused admission to voluntary services. I think this is really significant. Now, I've been trying to find out how often this is being used, but even if it isn't used enough, it's there. So the Mental Health Review Tribunal has power to actually order that the person be treated. They can also order that the matter go back to the mental health professional concerned to reconsider, but they nevertheless have the power to say, you must treat this person. And again, that ties into what we've been hearing, that people are often told, you're not sick enough, we don't have the resources, we don't have the beds available, go away until you're really bad. This really changes, I think, the focus here, the fact that a tribunal can order a person to be treated. It's very controversial, obviously. Mental health professionals don't want to be told what to do. And in some ways, it's a matter of judicial officers telling the government and the policymakers, you've got to put more resources into mental health services. But I still find it very interesting, and I'd be fascinated to hear your perspective on this, whether this is actually workable. Another aspect to providing access to good quality services is that in Victoria we've actually had a really interesting initiative called the Multiple and Complex Needs Initiative. And this was set up under legislation, and it set up a panel that actually coordinates services for those with multiple and complex needs. Very small cohort, but it has been incredibly successful. And the review of this found that it wasn't necessarily that the person, him or herself, had complex needs, it was actually the system that was complex. And all these different fragmented units weren't talking to one another. So having a legislative body actually coordinate that has been really significant. Now, the panel itself has been disbanded, but the initiative still lives on in terms of it being coordinated across various services. So I'm happy to talk further about that in case you're interested as well. All right, the last trend that I want to talk about is the inclusion of families and carers in mental health legislation. And certainly the message that we got with the interviews was that carers felt that they just weren't being heard. They weren't given enough information, they didn't know what was going on. And I think it's important that if there's a move to community care, families, carers are often the ones that pick up the slack. They want to know what's going on. So how can this be included in legislation? I just want to give you some examples. These are the three areas that certainly cropped up, that carers wanted involvement in decision-making processes, in review processes, and they wanted access to information and for their voices to be heard as well. In South Australia, we've actually enacted a Carers Recognition Act, so you can have legislation that has very broad principles that recognise the role that carers can play. Now, these are really more sort of the big picture guidelines, but nevertheless it's important, I think, that this sort of legislation is enacted. Then we can have more detailed provisions. So, for example, Mental Health Care and Treatment Scotland Act requires the views of carers to be taken into account. And this, I think, provides an example of a really progressive way of including carers and family members. There's also specific rights to be consulted at various times in the decision-making process. The named persons scheme in the Scottish Act allows for the primary carer to be appointed in the absence of a patient's nomination, and again provides rights to actually participate in the decision-making process. A review has found that this is actually working quite well, that carers, family members are feeling that there's more disclosure, that their voices are being heard and that they're getting the information that they require to care for the person concerned. Involvement in the review process, again in the Scottish legislation, carers can be involved throughout tribunal hearings and so on. And this, again, in the reviews of this scheme, seems to be working quite well, that these tribunal hearings are less adversarial. There's more of an information exchange going on. There's also an issue about access to legal representation. That, of course, is subject to economic matters, but carers certainly would like to have more representation themselves in terms of tribunal hearings. In relation to information, getting the information to enable proper care of the individual concerned, there are different ways that legislation can do this. So, for example, in Victoria and South Australia, disclosure is permitted subject to an express refusal. The Victorian Mental Health Act provision on this is incredibly complicated. So what it does is that it says information is confidential except, and then it goes for pages and pages and pages with exceptions. So in practice, what we've found is that mental health professionals just don't understand this. And because confidentiality is a cornerstone of medical ethics, the general default setting is we won't tell the carers anything. That's not what the legislation says. It's not the intent of these provisions, but I think it's just been misunderstood. The other way of doing it is to, as in Scotland, enable mandatory disclosure so that the named person is required to be notified in certain circumstances. And certainly the carers we've spoken to have said that this has worked well. However, there have been a few hitches. For example, a couple of carers have said that they were sent photocopies of the entire file on their loved one, and they didn't know what to do with it. So what they want, obviously, is specific information, not just a stack of papers. The other way of doing access to information is just to have it as a general principle. So again, this is more a guideline type structure. So again, Scottish Act, South Australian Act have provisions that set up the general principle that carers should be provided with information. Okay, so where does that leave us? I think the context of the convention is very important for mental health law reform. There are obviously conflicting perspectives on the scope of mental health laws. I think what's important is that we actually address the concerns of those whose voices have been too often unheard. We can use a lot of different ways of supported decision making, advanced directives, the use of advocates and so on, more attention being paid to the wishes of carers. Obviously, just having laws in place doesn't lead to the provision of new services, but the law does shape the way mental health services are delivered. And in my view, I think in the past the focus has perhaps been too much on involuntary detention and treatment. What I think the CRPD is doing is emphasising that it should be voluntary treatment wherever possible with proper supports in place. This inclusion of positive rights, including access to good mental health services, is incredibly significant. And I think, and I might be being a bit too optimistic here, I think this can be used to put more pressure on governments to provide adequate mental health services. It certainly seems to be the case in Australia. There's a lot more emphasis on mental health now. We have mental health ministers in many states and at a federal level, and the government, both federally and in certain states, is putting much more money into mental health services. So to some extent, this is working. All right, so in conclusion, if you want to learn more about the work we've been doing, this is a whole stack of books that we've produced over the past 4.5 years. There's some of the books that have come out, and I know some of you are familiar with the Rethinking Rights-Based Mental Health Laws. Phil has a chapter in it, Mary has a chapter in it. Wonderful, wonderful collection of chapters on different rights-based perspectives on mental health. And the other one is just, again, an edited collection on international trends in mental health laws. So I'll leave you on a positive note. I'm not sure whether I'm taking questions now, but I kind of like this idea of having a mental health clinic based on this. Okay.